It's my privilege to introduce to you the president of the Catholic University of America, who joined us in just this last July. And I'm going to give you the really short version of his background, just so you're aware. This could go on for hours, but Peter Kilpatrick was most recently the provost and senior vice president for academic affairs at Illinois Tech. He had gone to there after being the dean of the College of Engineering at Notre Dame for a decade. And he had gone there after being the department head and a member of the faculty at North Carolina State for, I think, 25 years. He had, yeah, I guess I shouldn't, suggest a calculation there, but he has, thousands of citations to over 100 published articles. He has, 12 patents. He's a chemical engineer, is bringing that, engineering precision to this new post, and we're grateful for it because he's also a person of deep faith and mission. And I just want to have you welcome our president, Dr. Peter Kilpatrick, who will introduce our speaker.
Great. Thanks, Steve. So wonderful to be with all of you here tonight and to introduce and welcome my good friend Carter Snead, who will give the lecture tonight at our dinner. So first of all, I'm just delighted to be here at the inaugural conference of the Center for Law and the Human Person. It's such an important issue. When I was elected to be the president of the Catholic University of America, I began to ask myself, what should I be doing for Catholic higher ed? And so I read Ex Cort Ecclesiae, I read all the documents, Newman's book, all the documents I could on Catholic higher education, and the conclusion that I came to is that the most important thing we do at a Catholic university is help persons, human persons, fully discover who they are as human persons. And that's worth applauding. That's worth applauding. That there's nothing that's more important than that. And so I'm delighted that our guest speaker tonight is going to focus on that exact issue. Carter Snead's talk tonight is entitled Anthropology, the Indispensable Tool for Grasping and Shaping Law. Carter's an old friend. I've known Carter now for 15 years. He's one of the world's leading experts on public bioethics, which is the governance of science, medicine, and biotechnology in the name of ethical goods. And he wrote what I consider to be really a groundbreaking book called What It Means to Be Human, The Case for the Body in Public Bioethics. And I think other people thought it was groundbreaking too, because the Wall Street Journal named it one of the 10 best books in the year that it came out. And Yuval Levine called it among the most important works of moral philosophy produced so far in this century. So get the book. In fact, get the book and read the book. But Carter's done a lot. In addition to the book, he has more than 70 journal articles, book chapters, and essays, and they've been published in really outstanding venues, law reviews, and Harvard's Law Review Forum, the Vanderbilt Law Review, the NYU's Law Review, et cetera. So he's very accomplished as a scholar. Prior to joining Notre Dame, by the way, he is the executive director of the Nicola Center for Ethics and Culture at the University of Notre Dame. And prior to joining, and a professor of law, prior to joining Notre Dame, Carter was general counsel to the President's Council on Bioethics, which was chaired by Dr. Leon Cass, where he was primary drafter of the report, Reproduction and Responsibility, the Regulation of New Biotechnologies. Carter received his JD magna cum laude from Georgetown, where he was elected to the Order of the Coif and his Bachelor of Arts from St. John's College in Annapolis. He clerked for Judge Paul Kelly of the U.S. Court of Appeals for the 10th Circuit. And one of the discussions Carter and I had right before the event tonight was, what does it mean to be a person? There's a classical definition of who the person is. Boethius said, the person is an individual substance of a rational nature. And I would argue that is an impoverished view of a human person. And yet it's dominated our philosophy and our psychology for 1,500 years. And so many people now are asking, gee, can't we get a better definition than that? So I was at a talk last night that David Walsh gave. David is one of our political philosophers here at CUA. And he said a person is relational. A person is someone who engages in mutuality. Carter and I had a little debate about whether that was close enough, whether it encompassed enough of the human person. How does it deal with people who are disabled? How does it deal with people who may be unconscious but are still persons nonetheless? So I think there's an interesting debate and conversation that we need to have about this whole idea of relationality, because that's who God is. God is three persons and one nature. God is relational, and we're in his image and likeness. So I look forward to Carter's remarks tonight. He means a lot to me. He's a wonderful friend. Welcome to Catholic University, Carter.
It is a very special treat to be with you all this evening for so many different reasons. First of all, to be with my very dear friend, Peter Kilpatrick, who is an extraordinary human being, and Catholic University of America is richly blessed to have him as your rector magnificus, your president. You are in amazing hands with Peter Kilpatrick. God bless him, and God bless all of you. Also, the Center for Law and the Human Person is it's such an exciting new project and so essential to thinking about law generally. And you are in amazing hands with my dear friend, Professor Elizabeth Kirk, who has been, with her husband Bill and their family, been longtime friends of our family, my wife Lee and our kids. And so you are in great shape there too. So Catholic is going from strength to strength with your president and with this center and with Elizabeth and with these amazing speakers that we've had today. This is an extraordinarily auspicious beginning to what will be a very important and essential center at this the Catholic University of America. I have a glass of wine with me. I hope no one's scandalized by that. As someone pointed out, maybe it was Mark, that Roger Scruton, Mark DiGirolamo, a wonderful friend and scholar, that Roger Scruton, it adds to the conviviality of the moment to have your wine with you when you participate. So I actually was an adjunct faculty member here at Catholic University Law School from 2002 to 2005 when I was working with the President's Council on Bioethics and came to realize how special the students are and what a special community of learning the Catholic University of America is. My wife did doctoral studies in philosophy here at the Catholic University of America from 2000 until 2006 and realized what a special place the philosophy department is. Our friends Joe Capizzi and others in the theology department, I see, where's Joe's sister-in-law? There she is, sister. You have a rich treasury of gifts here at the Catholic University of America and Washington, D.C., and it is, the nation is better for it, and the world is better for it as a result. So it's a real treat for me to join you here this evening, and I'd like to thank Elizabeth for inviting me and everyone here who's come to come out on is it Tuesday? Today's Tuesday? Tuesday night to hear me speak. So my talk, I hope my talk is reinforces and is aimed at the sort of heart of what I take this project to be at the Center for Law and the Human Person. I couldn't agree more that focusing on questions of human identity and human flourishing is central to the question of what law is and to the question of what law should be, and is a rich point of entry, the richest point of entry, I think, into analyzing law and public questions. And so what I'd like to talk about this evening echoes in large part the claims of the book that Peter mentioned, which you can purchase also. Even as we sit here, you could purchase it on your smartphones. The book makes two claims, and this evening I'm going to make two claims. The first is a methodological point, which I've already alluded to, namely that the richest and most potent method of analyzing matters of law generally, and in my field of public bioethics particularly, which is a species of law, and I'll get more on that in a moment, is what I describe as an inductive anthropological inquiry. And that sounds very highfalutin, but it's not. All it means is you take the law or policy or whatever's under consideration as you find it. So it's inductive. You're not beginning with principles and working down, applying them in that way. You're taking the landscape as you find it. And it's an anthropological inquiry, meaning you're asking the question about the law or policy at issue. You're asking the question of what vision of human identity and flourishing anchors and animates this law and policy. What assumptions are being made about who and what we are, how we stand in relation to each other, and what we owe to each other? I think that's a fundamental question to ask. I think that's in some ways the deepest question you can ask when confronted with, and that's what we try to teach our students. I know they teach them here at Catholic U and at Notre Dame Law School as well, that law is irreducibly normative. I'll say more on that in a second. I think this anthropological inquiry is essential. And then there's a substantive claim that we can get into if we have time. In the abstract sense, we'll talk about it quite a bit, but then if there's time, we'll talk about it as applied to the context of a particular area of law that's been in the news and in the public consciousness recently, the law and politics of abortion. But the substantive claim is that the dominant anthropology and the vital conflicts of American public bioethics resembles what philosophers like Charles Taylor and social scientists like Robert Bellah have described as expressive individualism. The law and policy goes badly wrong insofar as it embraces a vision of human identity and flourishing that can't make sense of the lived reality of human embodiment. That is, our vulnerability, our reciprocal dependence upon one another, and our subjection to natural limits. And therefore, that anthropology is not a suitable foundation for public bioethics. It's not a suitable foundation for disability law either, as Lisa Schultz pointed out. It's a problematic imaginary, it's a problematic set of presumptions about who and what we are that captures only a very small sliver, really the most privileged group of the human community, and leaves many, many others behind. And what's needed, and what the book offers, and there's only time to sort of scratch the surface this evening, is a kind of anthropological corrective, a filling out of what it is that it means to be a human being. Which is not to say that freedom and particularity and our cognitive engagement with the world aren't important. They are. And they are an essential part of who and what we are. But they're not the whole story. And where they fall short in describing the whole story is where we run into very serious trouble. Okay, so the framework for the talk is pretty straightforward. I'm going to sort of talk a little bit about an anthropological analysis of law and policy and what I mean by that. I'll talk a little bit about public bioethics as kind of the concrete point of departure for this evening's remarks. You can't really talk about it in the abstract. You kind of have to have something to latch onto, some legal domain to latch onto. And public bioethics is the one that I'm going to do because it's what I work on. I'm going to talk a little bit about expressive individualism, which I think is an incomplete conception of the self that is forgetful of the body, but nevertheless dominates in American law, especially in the field that I focus on. And then I'm going to talk a little bit about the corrective of remembering the body. That is an anthropological corrective of focused on the goods and practices and virtues for our shared embodied lives. Expressive individualism assumes that human beings flourish in a particular way and therefore they need certain kind of preconditions to flourish. I think that's not right. I think that because we're embodied beings, we need an additional set of preconditions to ensure our flourishing and even, frankly, our survival. So, what do I mean by law and anthropology? I'm not talking about the sort of field of study in modern universities. I'm not talking about Margaret Mead. I'm talking about the sort of original sense of what it means to be and flourish as a human being, an account of what it means to be and flourish as a human being. But before getting to that, it's something important to just begin with, and that I think is important at any Catholic university, is that law itself is irreducibly moral and ethical. It trades in the normative. You hear frequently, hopefully not so much in law schools, although I think you do hear it in law schools, like, oh, the law and morality should be kept entirely separate. Keep your morality off my body, for example. But the truth of the matter is, law by its very nature is irreducibly normative. It reflects, because all law concerns goods to be pursued and harms to be avoided. And so in that way, It reflects the goods that people hold dear and the harms they seek to avoid. I'm not normally in the habit of quoting Oliver Wendell Holmes for bioethical wisdom, but nevertheless, he was right when he said, after a fashion, that law is the witness and external deposit of our moral life. You can learn an awful lot about what a polity believes and cares about by analyzing what its laws are. But law doesn't merely reflect and communicate what a polity cares about. Law also shapes attitudes. It has a pedagogical function. It shapes public attitudes about goods and harms. Law is, to quote Brandeis after a fashion, is the omnipresent teacher. And so, maybe we agree to that, but why are we talking about anthropology? Why are we talking about human identity and flourishing? Well, Walker Percy, one of my favorite novelists, said that everyone has an anthropology, right? There's no not having one. If you say you don't have one, all you're saying is that your anthropology is implicit. It's a set of assumptions you've not thought to call into question. You have to have a set of anthropological premises, generally, but especially in the law, and that's because of what law is. Law is normative, it's irreducibly so, but at its base, what law is an institution about and for the protection and flourishing of persons, period, full stop. Law is about and for the protection and flourishing of persons. That's what law is for. And therefore, to be intelligible at all, law has to rest upon usually undeclared conceptions of what it means to be a person. Law doesn't mean it can't operate without having a working definition of what it means to be and flourish as a person, since its business is to protect persons and to promote their flourishing. And therefore, I argue that the richest and deepest understanding of law is necessarily anthropological. It means that you have to analyze the vision of identity and flourishing in which the law is anchored. You have to ask the question, who and what does the law assume persons to be? Which is why Elizabeth's project here is so essential, okay? And why it asks the right question, even in the name of the entity itself. So, public bioethics will be the kind of concrete framing for the rest of our conversation. Public bioethics, as Peter pointed out, is the governance of science, medicine, and biotechnology in the name of ethical goods. It's an area where the law and governance comes into contact with these ethical questions that arise from advances in biomedical science, biotechnology, and the practice of medicine. Okay? It is not merely a field of intellectual inquiry. It certainly relates to the field of intellectual inquiry that is bioethics, but public bioethics means the law and governance. Okay? And it is fundamentally concerned with human vulnerability, human dependence, human frailty, and finitude. It's about concretely procreation and pregnancy and babies and wasting illnesses and devastating injuries, the desperate enrollees in clinical trials, fearful patients, the disabled, the elderly, the dying, and the dead. Put a different way, public bioethics is most deeply about the meaning and consequences of human embodiment. The fact that we experience ourselves and one another and the world around us but more specifically, more precisely, more accurately, as living and dying bodies. We are bodies. We're not merely bodies. We are a dynamic, integrated unity of mind and body. But we experience the body is the locus of personal presence on the planet Earth and on this side of the veil of darkness that we will. Anyway, I'm not going to get into that. We got the skulls on the thing. You don't have to worry about that. So, American public bioethics. We don't really need to get into it. I want to leave a lot of time for questions to answer. American public bioethics was born in the late 60s and early 1970s as a reaction to certain scandals involving terrible abuses of very vulnerable individuals. The Willowbrook School is a perfect example of that. Henry Beecher, that's who you see wearing what looks like a bathrobe, but in fact it is like a white lab coat. He was an anesthesiologist at Harvard that wrote an unbelievably influential, although very modestly named article in the New England Journal of Medicine in 1966 called Ethics in Clinical Research. And his research revealed 22 research experiments, conducted by the most elite institutions of research in America, including the US government, wherein the most vulnerable people were exploited and mistreated. In all but 3 cases, the concept of consent was not even part of the encounter with the researchers and the human subjects. But at its sort of worst, you have situations involving the injection of hepatitis into intellectually disabled children at the Willowbrook School. You had live cancer cells being injected to elderly patients suffering from dementia. in the New York Chronic Jewish Disease Hospital, and so on. In the middle image, you see the sharecroppers of Tuskegee, Alabama, who were systematically deceived for decades and decades and decades by the Public Health Service, who were conducting a natural history study on untreated syphilis and the trajectory and development of untreated syphilis in a patient who doesn't, and they systematically deceived poor African American sharecroppers for decades and decades, and even, and sort of most scandalously, in the middle of the 1940s, when antibiotics became standard of care for treating syphilis, they did not reveal that to these folks. They did not provide them with medication. They did not, and in fact, there's reported evidence that they even colluded with local healthcare authorities to prevent those individuals and families from getting care, and the consequences were devastating. And then the third image you see, and a lot of people have heard about Beecher, and a lot of people have heard about Tuskegee. Not a lot of people talk about this third image here, which is represents a scandal from the early 1970s, 1973, in which it was revealed that NIH was discussing their role in funding research involving recently aborted but still living ex utero newborns, where these newborns would be kept alive for extended periods of time after they had been born, delivered by hysterotomies in Scandinavia usually, where that was the primary method of abortion. You'd have a living neonate, a living newborn for some period of time, and these doctors would conduct experiments involving all kinds of interventions that extended their life while they could do things that were painful and scandalous to these newborns. And so that also provoked a very significant controversy, all these scandals culminated in the National Research Act of 1974 following a series of hearings by Senator Ted Kennedy. But the unique features of American public bioethics and why it's a fertile area to talk about these principles of American law and anthropology is because they are uniquely complex, they are contested, they are vital conflicts, and frequently what you find is the solution to these scandals is to seek refuge, as we did in the disability rights laws that Lisa talked about, in the doctrine of autonomy, right? Informed consent. That's the solution, right? That's the solution to these research scandals. But if you think about the scandals themselves, it wouldn't have helped the children of Willowbrook to ask them if they wanted to be injected with live hepatitis. It wouldn't probably have helped people who are suffering from crushing poverty and systemic racism, to seek their consent when meaningful consent may not be possible given the circumstances of the moment. And you certainly can't ask a newborn, just aborted, living but imminently dying baby if they would like to submit to experimentation. It's a category mistake, right? It's a category mistake that reflects our natural American kind of almost gravitational attraction to principles of autonomy and self-determination as a panacea for any kind of problem. So what's the problem? How do we go wrong? What is it? In what sense has the concept of the person gone wrong in American public bioethics? And I would argue in other areas as well. It is the embrace of this concept that, as I say, closely tracks the principle of expressive individualism. And we don't have time really to get into the kind of intellectual genealogy of expressive individualism. It's a very interesting topic. You can read chapter 2 of my book if you're interested in these questions. But there's a lot of interesting connections. For those of you interested in literature, there's a lot of very interesting connections to the Romantic literary movement, as well as literature that predates that, as kind of showing pristine examples of the sort of the imaginary of expressive individualism. But at bottom, what it means is the person is conceived as an isolated, unencumbered, atomized, that is isolated and separated, individual self. The person is defined solely by their will. And the body is deemed as a kind of instrumental attachment that is used to pursue the projects of the will. Persons are defined as individual consumers and choosers. Human flourishing is defined by the pursuit of the projects of one's own construction. There is an imperative to live your originality, to consult the interior of your sensibilities, to find your own authentic truth, to express it, and to configure your life plan according to it. You are, in the words of Michael Sandel, a self-originating source of valid claims. Expressive individualism is what philosophers call anti-teleological. It's the proposition that natural or external givens of the world are not normative or even a useful guide to negotiating the world of nature and the world of the physical world. The only thing that is unique and definitive for you is the inner voice, is the inner voice. There's no such thing as an unchosen obligation or constitutive attachment. Persons encounter each other either as collaborators in mutually beneficial goals, but frequently as adversaries, clad, in the words of Carl Schneider at University of Michigan, in the armor of their rights. Ethics becomes reduced to propositions about autonomy, the highest good to which all others are subordinated. Injustice becomes reframed as a constraint on freedom to pursue the projects of your own choosing. And then government, the role of government primarily is to remove constraints, public constraints, private constraints, maybe even natural constraints, and otherwise provide the conditions or the assertion of the unencumbered individual self. Now, this is a very sexy vision of what it means to be a human being. The kind of atomized individual bestriding his environment, bending it to his or her will. It's a very attractive vision to adolescents, for example, but it's false, right? It's false because, and you know it's false simply by consulting your own kind of autobiography, your lived experience. We don't begin our lives with the resources and capacities to bend the world around us to our will, to enter into transactional relationships with other people or other things, or to instrumentalize our own bodies and the world around us to pursue the projects. Or we can't even formulate future directed plans cognitively. We can't do that. In fact, the human lifespan begins, as Lisa said, in a condition of complete and utter dependence upon others by virtue of our bodily limitations as embodied beings in time. And we gradually climb a gentle, God willing, if everything goes the very best it can possibly go in terms of our life and our health and our environment, our conditions and our social setting, a gentle kind of curve upwards to the height of our powers, at which point we pivot immediately back downwards to a, God willing, a gentle curve to complete and utter dependence again. Now, there are many people that don't have it that good. Most people don't, right? There are people who have disruptions and they become dependent earlier. Some people are dependent for their entire lives. And the world of expressive individualism, the vision of expressive individualism, fails to take those individuals. They can't see them. They can't make sense of them because they fall outside of the definitional context of what it means to be a person or a human being. And the principal problem here, why does it go wrong? And this is borrowing from our wonderful friend at the Nicola Center and sort of spirit animal, Alistair McIntyre. To borrow his words from another context, forgetful of the body. Because lived embodied reality, we are fragile, corruptible bodies in time, we are vulnerable, we're subject to natural limits, and we therefore are mutually dependent upon one another for our survival. We are, as McIntyre says, all human beings, because of what it means to be embodied, exist on a scale of disability. And what human beings need, what embodied beings need, is not the freedom of the unencumbered will. What we need, first of all, to survive, are what McIntyre calls networks of unconditional and uncalculated giving and graceful receiving. Networks of people who are willing to make the good of others their own good without counting the cost and without seeking anything in return. We need that for our basic survival, and for most of us, that network began in its pristine form with our parents, right? The parent-child relationship is a pristine example of network of uncalculated giving and graceful receiving. And we wouldn't be here right now if somebody didn't do that for us when we couldn't care for ourselves. But it's also essential for human flourishing. To become the thing, to learn how to become the thing, independent practical reasoner, as McIntyre calls it, by participating in these networks, we survive and we learn to become the kind of individual, the kind of person that can do this very same thing, that can make the good of another our own good. And that guarantees the sustainability of these networks and the continuation of the species. But it also teaches us to be the very thing that we are meant to be, which is to say, we are made for love and friendship. And you can see that by reflecting on principles of embodiment. And you can see immediately the myopia of expressive individualism. It can't recognize the unchosen claims of the weak, including children, the disabled, and the elderly. It results in loneliness and dislocation and alienation. There are no constitutive relationships that aren't instrumental and transactional. It's death-haunted. As Solzhenitsyn says, when you are the central point of the universe and you die, that's the extinction of the entire universe at one stroke, and therefore your life is perpetually haunted by the prospect of death, the howl of death. And then, of course, as Robert Bellah and Charles Taylor and others have flagged for us, it obviously leads to the erosion of social and familial ties. So what do we do? How do we correct the deficits that expressive individualism creates in our law, public policy, and even our self-understanding, we have to remember the body. We have to embrace the goods and practices and virtues for lived, embodied reality. Again, to participate and sustain these networks of uncalculated giving and graceful receiving, we have to practice what McIntyre calls the virtues of acknowledged dependence, from his wonderful book, Dependent Rational Animals, which I take here and then enlarge upon a little bit. But the first set of virtues are the virtues of uncalculated giving, the virtue of just generosity, giving to another in proportion to his or her need. Hospitality, welcoming the stranger because they're a stranger. Misericordia, which our wonderful friend John O'Callaghan writes so beautifully about, which is the accompaniment of the other in suffering. To take on the suffering of another as your own suffering, right? In the same way that sharing the good of another in friendship, misericordia is taking on the suffering of another as your own. In the context of medicine, it means seeking to heal and care for and relieve suffering, but when that's not possible, to accompany the other. And then on the other side of the coin, we have the virtues of graceful receiving. The principal virtue, of course, is gratitude. And gratitude engenders these other virtues: humility, the ethic of giftedness. Everything is given to us. We didn't build this, we didn't earn this, we're not here because of something that now of course we can participate, but we need to be grateful for what we have been given. And that leads you to kind of be open to the unbidden, as Michael Sandel and Protestant theologian Bill May has said, to be tolerant of imperfection, which becomes essential in the context of loving people rightly we're all imperfect, but people who've suffered from imperfections that are particularly strong. Solidarity, recognizing our mutual connectedness. Human dignity, the notion that every single person is equal in their basic value and is unrepeatable and is of infinite, inviolable status. Truthfulness. All of these virtues can be understood through the lens and under the aegis of friendship in its deepest sense. So we practice these virtues of acknowledged dependence, virtues that take you outside of yourself. And I say, to make it even more concrete, the paradigm here, and it's relevant to the context of what we're talking about in bioethics, is the paradigm of parenthood. Okay, parents don't care for their children, and there are different ways to care for your children. And as I can tell you from personal experience, one way of caring for your children sometimes is to make an adoption plan for your child, right? And to sort of delegate to another the role of parents for that particular child. So I'm not making a claim that those who are not capable of parenting their own children should be made to do so. That's not. And in my life, it's important that I'm not saying that. But what I am saying is that parents don't take care of the children because they've been engaged in some kind of mutually beneficial contract to do so. It's not a transaction. It's what it means to be a parent. It's an unchosen obligation that inheres in the relationship itself. And in the same way, children don't have to earn the right to be cared for by their parents. It inheres in the relationship itself. Children are entitled to the unearned privilege of being cared for by their own parents. So, now, I actually haven't kept track of how long I've been talking for, and I'm happy to open for questions, or I can make this very concrete for you and talk about how the law of abortion in America has reflected, up to a point, the very problem that I've been putting my finger on. So I will ask the director, should I go into this, or should we open the floor for questions?
I think 5.
5-ish minutes, I can do that. That's easy. So I love this slide because I used to give this talk about the jurisprudence of abortion. I give like 50 years of American abortion jurisprudence, and now I don't have to do that anymore, praise Jesus, because of the court reversing Roe and its progeny in the Dobbs case. But if you want to understand how badly American abortion jurisprudence went wrong, you could tell a story about, and it would be true, about a method of constitutional interpretation that untethers itself from the text, history, and tradition, and then underwrites kind of freedom of justices to obliterate the difference between legislating and judging and imposing on, one's own normative vision under the auspices of reading a text outside of those tethers that I mentioned. And that's certainly true. But once untethered, once Justice Blackmun was released from the obligation, releasing himself and arrogating himself the freedom to simply write on a blank slate what the law of abortion in America should be, notwithstanding what it had been since prior to the nation's founding, where the political branches of government were entitled to extend the protections of the law to the unborn child. What he did, in fact, was to graft onto the Constitution a set of propositions rooted in a very false and impoverished anthropology that looks very much like expressive individualism. He began by talking in Roe v. Wade about the right to, he invented the right to abortion based on a kind of balancing of what he took to be important human goods. On the one hand, he took what were taking a step backwards, he, first of all, atomized the participants in this human dynamic. He said he didn't talk about the relationality of mother and child. He didn't talk about biological kinship or connection or the fact that the womb is the place of belonging for human beings as a species. He began by applying an acid to that relationship and atomizing and isolating woman and unborn child and treating them not as relatives, but as strangers. And saying, okay, what we have here is a clash of interests among strangers fighting for the scarce bodily resources and human resources and future of the mother herself, who's indisputably a person. And so on the one side, he enumerated the true and serious burdens that can come with an unplanned, unwanted pregnancy. But then he immediately pivoted to the burdens on not just the mother, but everybody of an unwanted parenthood, which is important to think about when you think about the errors of Roe and Casey. And he said you have all these very serious burdens. Some are physical, some are psychic, but others are social and economic and familial and stigma related. And they're all very serious over here. And then on the other side of the coin, you have a kind of being of uncertain, in the court's judgment, ontological and moral status. But they weren't uncertain about it. They called it potential life. They said, that is a thing that you states are forbidden to protect as if it were a person. Now think about that for a minute. That's not about interpreting the 14th Amendment. That's about saying the Constitution forbids states and the political branches of government from protecting the unborn child as if it were a person. That's in our nation's founding document, okay? And so it's the state's interest in protecting this kind of questionable thing, subpersonal thing, potential life, versus the burdens on a very real and recognizable person, the mother. And so when you frame it as this narrative of conflict, of atomized individual strangers contending for scarce bodily resources, when the relationship is defined by will and choice, and then the definition of health is any aspect of the woman's well-being, it's not surprising the court came up with a license to use lethal violence to secure that freedom. And they traded in concepts of privacy, of the right to be left alone, isolating and atomizing. And by the way, one of the consequences was isolating the mother from her child was to abandon her, to say, it's your body, it's your choice, it's your problem. Absolving all of us from the obligation we have to rush to the aid of mother and child in conflict. And then Casey, 19 years later, adopted a very specific kind of concept of freedom and liberty that looks very similar. Again, talking about the same kind of goods. So the world of Roe and Casey were a realm of strife and conflict among strangers, atomized individuals, no unchosen obligations, no unearned privileges. Natural givens were irrelevant. And therefore, we wound up with 50 years of abortion jurisprudence that prevented us from protecting mothers and children and babies the right way. And now the court has returned to us that authority after 50 years. And we're free finally to care rightly for moms and babies and families, and fathers, of course, as well, and communities, from conception throughout all life stages. And so what we have to do in that respect is to remember our deep connections to these women and children and put them first, and to realize that the crisis that Justice Blackmun saw as a war of two strangers against one another is in fact a crisis involving a mother and her child. In any decent community, any decent society, when you hear that a mother and child, if someone were to come into this room right now and say, there's a mother and baby outside that need our help, everyone would get up. We wouldn't say, well, who has the property right? And we would get up and we would rush out and come to their aid. And that is what we have to do now as people who believe in the intrinsic equal dignity of every human being from conception to natural death, who believes that we are made for love and friendship. What we have to do now is to hear that call and to recognize our brothers and sisters in the womb and in poverty, and it'll have beneficial consequences across the legal landscape and legal context. But we have to do it, and we're called to do it, and it's our obligation to do so, but it's a happy and joyful one, and God bless all of you, and thank you for your attention this evening.